Thanks, Meredith. All right. Land titles absolute applications. You all look extremely excited. So we'll chalk that up to the hospitality suite. In any case, I'm going to carry on. So as Meredith was saying, I'm a lawyer at Merovitz Potechin. I started there a couple of years ago. And I'm going to start with a story. One of my mentors there is Bram Potechin. And when I first started there, Bram came into my office, and some of you may know Bram. He's older, he's experienced, passionate about his work, he's extremely conscientious. So one day around the time I first started, he comes into my office and he says, "Matt, something's keeping me up at night." I say, "Bram, that's horrible news. What's the problem?" He says, "Well, I've been having these nightmares." And I say, "Okay, that's awful. What are these nightmares about?" And he says, "Well, I'm just about ready to register a brand new plan of subdivision for a client, big new subdivision, lots of units, and I'm about ready to click the button, the register button in TerraView, ready to register my application when I get an email from the land registry office. It says, 'Mr. Potechin, I'm sorry, you won't be able to register your plan of subdivision. The land is in the LTCQ system. You have to upgrade to Land Titles Absolute Plus.'" Well, Matt, I woke up in a cold sweat, heart pounding, sick to my stomach, realized it was all a dream. I said, "Bram, that's awful. What can I do to help you? I'm a new associate here." He says, "Matt, the very first thing you do, when you get a file from a developer and you're tasked with the development work, check the qualifiers, the first thing you do, to make sure that it's either in Land Titles Absolute, or if it isn't, upgrade to Land Titles Absolute Plus as soon as possible." So I say, "No problem, Bram. I'm on it. Got it taken care of." So you have to love Bram. If you know Bram, you know that he would never let that happen. And in all likelihood, this sort of problem likely would have presented itself earlier in the process, in the pre-approval stage and so on. But his concerns are warranted. And if that situation did occur, in the best of circumstances, it would mean, in our experience on average, 2.5 to 3.5 months of delay, or at worst, a year or more. And those are very general. It depends on what sorts of issues can come up. But it's a lengthy process. So in the context of that, you might be asking yourself, what the hell is a land titles application for absolute title? Why do I care? Etc. So in short, what it is it's a process of taking an LTCQ PIN and converting it to Land Titles Absolute Plus. And why you would do that, if you're acting for a developer, you are not able to register a plan of subdivision or a plan of condominium on an LTCQ parcel. That's set out in the Act very specifically, the Land Titles Act. So it's a necessary step. And if you're acting for, say, a mom and pop client, individual persons, not a business, and they're rural or suburban, and they're just looking to clarify the boundaries to their property, for instance, this sort of application could be helpful. So how do you make the application? So I'll go through some of the basic steps here, some of the broad strokes. So the first place you want to go, there is a guide published by the former Ministry of Consumer Services and Business Services of Ontario entitled Land Titles Conversion Qualified, LTCQ, to Land Titles Absolute Plus, LT Plus. And it was, although published in 2001, it is essentially, quote unquote, the Bible for these sorts of projects. And it's a very easy to follow, step-by-step guide, complete with precedents, and it's the manual that you have to keep at hand when you're making these applications. You'll refer to it all the time. The first thing you'll need to do, likely, is to ask the surveyor to go out and prepare a new reference plan. There is an exception for using existing reference plans, but it requires the written approval of the regional surveyor, and I've never done it that way, and I believe it's a rare exception, but in any case. So the likely first step is to go out and make sure that the plan of survey is going to be prepared. So your surveyor is going to go out to the land. They will go on site. They will monument and so on. And one of the things they're going to be looking for when they get to the land, around the boundary, I'm sure everyone's seen a reference plan. When you look at it, around one of the parts on the reference plan, say it's part 1, you'll see on these sorts of plans physical evidence, if there is any, of what the surveyor identifies as things that could be possessory claims or misdescription claims, things of that nature, things that indicate that possibly an individual has, or a corporation or an entity has, some sort of right in the land pursuant to the LTCQ PIN. There are certain rights preserved. So things like fence encroachments, structures encroaching, utility wires, hydro poles, things of that nature. If they are there, they should be identified on the plan. And the reason they do that is because the LTCQ pins have that italic language in them in the top left of the document list. It's that italic language that most of us who see these all the time don't look at much when you're conducting your usual transactions, but it says something to the effect of subject to section 44 sub 1 of the Land Titles Act, except, et cetera, and then it lists some of the exceptions and claims that the PIN is subject to. And you'll identify some of the main ones, which are adverse possession, misdescription, boundary settled by convention, et cetera, et cetera. If you look at my paper, you'll see some examples. And by the way, everything's set out there, so if you forget everything I say, you can always refer back to it. So one of the main reasons you conduct these applications to get there is to essentially foreclose these claims. And so part of the reason the surveyor identifies them is so that you can then prepare your application, serve it on all the interested parties, and the guide will set out who you're serving them to. And there's a certain time period within which these parties have to make an objection to the application based on the claims that they have that are set out there. So once you have your survey in hand, your draft reference plan, you're going to send it to your searcher. Your searcher will usually be familiar with these sorts of applications, so you tell them what you're doing, the purpose of it, and they'll tailor the search to the application for you and make sure that all the documents that you'd be interested in are there. You do your review, and the critical thing in doing this review is to make sure you identify the parties that you are supposed to be serving with notice. You have to identify the proper recipients. And those would be the sorts of parties that are adjoining landowners, say those with registered easements in the land, or those with rights that the draft reference plan identifies by their whatever physically appears there as having a right in the land. So for instance, if there's a fence off the line, that it's pretty important that you serve that neighboring owner in case they have a possessory claim in the land. So the Land Titles Act is pretty specific in terms of section 44 sub 3, indicating that the only way that a possessory claim pursuant to the Act can be preserved after the land has been upgraded to Land Titles Absolute Plus is by deficient service. So someone could say, for example, pop out of the woodwork years down the line and indicate that they weren't properly served, and therefore they have a possessory claim. And these claims all stem from when these registry pins were converted administratively to land titles. These conversions accepted those sorts of claims when they were converted. So they will still exist until you go through this process. So then, once you've identified your notice recipients, you're putting together your notice packages. You'll have an application, you'll have the draft reference plan, you'll have a letter explaining what to do to send to these people, and you will also have a copy of a statement of objection. You send it out, there's a 30-day period, and individuals can file a notice to object. Okay, so the guide gets into a lot of detail on that. You just have to follow the guide. There are steps to file an application afterwards. If you receive no objections, that's exceptional. You just go through the process of pre-approval and upgrade. So coming back to the main theme, making the application early, the thing that Bram was concerned with. So it's a lengthy process. You've got that 30-day period where you have to send out your notices and wait for objections, but then you've got to go through your pre-approval process, et cetera. So without any problems, it's fairly lengthy. If you start to receive objections, that's when things get really difficult, or potentially so, because the applications cannot be completed and title converted unless the objections are resolved. When you send in your materials to upgrade for pre-approval, one of the certificates you're signing will say something along the lines of the objections, none being received or all resolved, and you'll have to show the Land Registry Office a withdrawal of statement of objection, likely a form to that effect in correspondence. The guide will tell you. But basically, you have to make sure you resolve them. So one of the things that can come up, let's say a neighboring landowner who has a fence off the line. Let's say there's a fence significantly off the line onto what your client owns legally pursuant to the reference plan. So the neighbor thinks that they own the land up to the fence while your boundary line goes further down, and there's a strip of land in between there that the neighbor indicates that they own. So they'll send you a statement of objection, and it should have materials in it like an affidavit, maybe a reference plan, something to that effect. And one of the ways you can resolve this objection, very simple, you can offer a monetary settlement. What do you want to pay them? You decide what that little strip of land is worth. You pay them in exchange for a withdrawal of statement of objection. You make sure you get it signed, and that should be satisfactory. You just keep all of the correspondence with you in case the Land Registry Office would like to see that. Another option is to revise the reference plan that you sent out at the beginning. So you exclude the lands that the neighbor is claiming, so that you're only claiming the non-disputed area. The neighbor will often likely want to have ownership of this strip, so they might ask for a new reference plan to be prepared with a part identifying the disputed strip, and then once you convey that to them in exchange for a withdrawal of statement of objection, it'll be complete. If the tests under the Real Property Limitations Act and the adverse possession are all made out, you can register your transfer, sign it off without having to go through Planning Act consent process. According to Sid Troyster's book, if the possessory claim is made out, then the neighboring owner in fact owns the land, and it's just a matter of adjusting paper title. So in that case, it's fine, but you have to make sure that those tests are made out first. Otherwise, you'll have to go through the consent process pursuant to the Planning Act or through some other exception process. So another common one you might see is return notices. So in that case, that happens a lot, and what you can do is you'll want to make sure you scour the internet, scour Google, try to find an address for service for this person. If you can't find one, what we often find is that if you suggest that you publish the notice in a local area through a newspaper or an online publication, that may satisfy the Land Registry Office officer on the file. You have to confer with them and see if that's acceptable, but we've often found that that can satisfy it if all other possibilities have been expended and you just can't find an address for service. Okay, so I'll just wrap up by saying these land titles, applications for absolute title, they're a useful tool for developers. They're a necessary tool, frankly, if you're putting down plans of subdivision, plans of condominium. They're useful for individuals who want to clarify their boundaries, but you have to act early, you have to act swiftly, be like Bram, do it early. I'm Matt Reardon, Merovitz Potechin. Thanks very much.